Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. If I appear to be a little tired today, I apologize. It's a Monday. I get up super early every Monday to be in front of my computer by 6:30 in the morning, ready to go, waiting for the orders list to come out of the United States Supreme Court as we anxiously await words on both the Snope v. Brown case and the Ocean State tactical case. But each and every Monday, it turns out to be a big, gigantic nothing burger. I know that has a lot of you very worried, and the question I get asked a lot is, should I be worried? Well, a couple weeks ago, I would have said, no, I don't really think there's a lot to be worried about, but I've done a lot more thinking, and I think there is something to be worried about, but it might not be what you're thinking. I'll explain it all in just a few minutes. So today, let's spend a few minutes and let's talk about why we should all worry about the assault weapon ban case. Okay, America, for the 138th time, we're going to talk about Snope v. Brown and Ocean State Tactical versus Rhode Island, both an assault weapon ban case out of Maryland and a magazine ban case out of Rhode Island. They have already been on the United States Supreme Court conference list now 8 separate times. Each and every time on Monday, we all wait for word and get absolutely nothing other than it's been rescheduled. Both of these cases have now been rescheduled for Friday, April 4th. That will be their 9th conference. Is that normal? No, it's not. No, these are far more conferences than what we're typically used to seeing. However, I will point out that the Dobbs case, the one that overturned Roe v. Wade, actually had 12 conferences, and that was obviously a very heavy lifting issue, as this would be as well. But I want you to understand, America, that even though we've had all of this delay, there's really only one of 3 things that can occur, okay? And the likelihood of each one of these occurring, we will discuss. And then I will tell you where I think we might want to start worrying. Okay, the first thing that could happen is the United States Supreme Court could just deny the petition, say no. Now, 3-4 weeks ago, I thought there was a higher likelihood of that, where we were in the time frame of things. In the last 4 weeks, there's been well over 400 cases that have been trimmed from the United States Supreme Court docket. So one would think now that if that was going to happen, that they were going to cut these cases, they would have done so already. I know there are some that are like, hey, listen, there may be a dissenting opinion that would be written on the denial of these petitions. We know the 2 justices who are likely to write that opinion, and candidly, they could cut and paste from a lot of their other previous writings and have that done pretty quick. So I think that although we're not out of the woods there, I would be incredibly disappointed to have sat through 9 conferences only to find out that they're like, no, we don't want to take this case at all. But the possibility is certainly still there. Now, if you want to talk about remote possibilities, you could get what's called a per curiam opinion. That is where all 9 justices go, well, this is obvious. Duh, of course it violates the Second Amendment. And you get a very short order from the court, sometimes not even assigned to a particular author, that just says, no, the court finds per curiam unanimously that this violates it, and they remand the case back. What is the precedent for that occurring? Well, believe it or not, that's exactly how Catano v. Massachusetts was decided. It was decided under a per curiam ruling that Massachusetts' ban on stun guns was a per se violation of the Second Amendment. What's the likelihood that you're going to get that with magazines and assault weapons with these 3 justices? Absolutely impossible. No, it's completely impossible. So I know there are people out there saying at this point they should just issue a per curiam opinion. I agree with that. Is it going to happen? It will be a cold day in hell before that happens. And then, of course, the thing that could happen, the one that most of you are rooting for, is that it is accepted for review and scheduled on the court's docket for oral arguments. Now, while that is exactly what we want, because especially if you live in one of these civilian disarmament states, they are going absolutely hell-bent on these people right now, disarming them in every way humanly possible. You need the Supreme Court to step in and stop this insanity. But this is what I may want you to be a little bit worried about, America, which is, how confident are you that you are in fact going to win this case? Let me explain this way, okay? If we just took Snope v. Brown and Ocean State Tactical before the United States Supreme Court in its current makeup, as it sits today, I believe, and I could be wrong here, but I believe that these 3 justices right here would absolutely, positively, and without a doubt say there is nothing wrong with what the state of Maryland or the state of Rhode Island is doing, that this is all well within the confines, where they'd probably come up with some rulings to the effect of Second Amendment doesn't protect these items, or God only knows, okay? But they are no way on God's green earth going to find these laws unconstitutional, okay? So we're down 3 votes right there. Now, I think you could safely say that these two justices right here, Justice Alito and Justice Thomas, they are going to be dead set against any of these bans. They clearly violate the principles of in common use and would vote to overturn these types of laws. That's going to leave these four justices here. Now, I believe that you could also safely bet that Justice Kavanaugh would also join Justice Alito and Thomas. And I also believe, and I know many of you may roll your eyes, that Justice Gorsuch would do so as well. Now, I get that many of you are dismayed that Justice Gorsuch authored the majority, 7-vote majority in the Vanderstock case, and I've seen many of you complain that, well, there's no historical analogs and they never analyzed it this way or that way. You got to understand, folks, you're not going to get a Bruin-like ruling unless you make Bruin-like arguments. And this argument in Vanderstock was made really on one of statutory interpretation with a set of facts that probably was not the best set of facts. So I don't think you could put a lot of stock into where Justice Gorsuch would come down on the bigger issue of assault weapon bans based upon the holdings of Vanderstock. But if you believe that I'm overestimating Judge Gorsuch, then I want you to know that what I'm going to tell you that you need to be worried about may be even worse than that, right? But let's put Justice Gorsuch over there. Okay, now, guess what? It's 4-3. Good guys are ahead right now, but now you got Justice Roberts and Justice Coney Barrett. Let's start with Justice Coney Barrett. I know many of you are very lukewarm on her. I know that she has made some rulings and some statements that have some of you a little skittish about whether or not she would really uphold constitutional principles. I think that if you go back and you look at some of her lower court writings as it relates to Second Amendment issues, she's pretty solid on the issue. But then I will also point out her concurring opinion in the Bruin case, which again raised a few eyebrows. So at best right now, I think we could say she's iffy on this issue, all right? And then finally, we get to Chief Justice John Roberts, the clear moderate of the conservatives on the bench and the author of the Rahimi opinion. And while I don't disagree with the holdings of Rahimi, I have said time and time and time again that there is the inclusion of tremendous amounts of language that did not need to be there, but I believe was put there to whittle away at the holdings of Bruin and to allow for judiciaries to more creatively ban people, places, and things. The whole term, a nuanced approach or relevantly similar, especially when we're trying to respond to more modern societal problems, all of which comes from the Rahimi opinion, means that in many ways Justice Roberts has actually set up the framework by which you could find potentially 5 justices to uphold these bans. And so is it entirely possible that if Snope v. Brown and Ocean State Tactical were to get before this United States Supreme Court, that the states of Maryland and Rhode Island would prevail by a vote of 5-4? I don't think that's completely out of the realm of possibility. And that is maybe why we should be most worried about the assault weapon ban case. Listen, we're going to go ahead and link up both the dockets for the cases down below so you can geek out and track them for yourself. If you got any questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. But if you don't, that's okay. That information, it's down there in the description box. If you got an idea for a video we should be doing around here, cool. Click on that link right there and tell us all about it. If you want to subscribe to the monthly newsletter, the ability to do all of that is right down there in the description box. And then finally, and most importantly, America, let's remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.